We will go on the record in the matter 25 CF 158, State of Wisconsin versus Luke Beechler. The state appears through District Attorney Kevin Schmidt in person. Mr. Beechler appears in person with counsel Joel Feliski. We're set today in this matter for a plea in sentencing. Mr. Feliski, can you please recite the agreement for the record?
Could we just wait 5 minutes? Because I think the victim will probably come.
Okay, then I guess we'll wait 5 minutes.
Sorry.
All right, we'll recall case 25 CF 158, State of Wisconsin versus Luke Beechler. The state appears through District Attorney Kevin Schmidt in person. Mr. Beechler appears in person with his counsel Joel Feliski. We do not have any victims apparently wanting to appear today. Correct, Ms. Bauer?
I don't see any.
But you're in victims' rights compliance?
Yes, Your Honor.
All right. So the parties have reached an agreement. Mr. Feliski, can you please recite it for the record?
Yes, Your Honor. The parties have reached an agreement here for Mr. Beechler to plead to count 1 in 25 CF 158 as amended to a misdemeanor OWI second, with count 2 being dismissed by operation of law. The parties will be making a joint recommendation for sentencing under the aggravated guidelines. My understanding of that being $1,711.50 in fines and fees, a 45-day jail sentence, a 17-month revocation of license, a requirement for an ignition interlock device to be installed in any vehicle operated by Mr. Beechler, along with a 45-day occupational wait period. I have reviewed and completed a plea questionnaire detailing this with Mr. Beechler. Your Honor, may I approach?
May. How many days jail did you say?
45 days.
It's aggravated guidelines.
I know, but I have blood alcohol content of 0.16, not 2022 point or 2.249. And if we do 0.16, it's 40 days jail, 16 months revocation. Tenth District Judicial District Guidelines for an OWI second, 0.16 or over 0.15, aggravated.
I must have just misaligned the lines when I did it. It's one higher, so it should be 40 instead of 45 days and 16 month. Oh, I'm sorry, wrong category. Yeah, 40 instead of 45 and 16 instead of 17 for the revocation.
Sounds like a better deal for you, Mr. Beechler. All right. That's the agreement you've reached, Mr. Beechler?
Yes.
May you please turn the microphone down? Thank you. Pleading guilty to an amended count of an OWI operating while intoxicated second offense. Is that correct?
Yes.
Formal motion to amend the OWI causing injury second and subsequent to a straight OWI second.
So made.
Granted. You're 37 years old. You have 11 years of schooling. You do not have a high school diploma or equivalent, but you can read, write, and you understand the English language, correct?
Yes.
Did your attorney go over this document with you?
Yes.
Did he go over it thoroughly with you?
Yes.
Essentially word for word?
Yes.
Did you understand everything completely?
Yes.
If there was something you did not understand, did you ask him to explain it to you until you did so?
Yeah.
Is that your signature on the second page?
Yes.
You are pleading guilty to that OWI fourth count. Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that first page of the plea questionnaire. Did your attorney go over those rights with you?
Yes.
And he went over them thoroughly with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that you're giving up those rights by pleading guilty?
Yes.
No mental illnesses or disorders, no alcohol, drugs, or medications in the last 24 hours?
No.
Because, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around November 2nd, 2025, that you operated a motor vehicle while under the influence of an intoxicant on a roadway or a highway of this county and state? Do you understand what the state would have to prove?
Yes.
You understand that this would be your second countable offense?
Yes.
You understand the minimum and maximum possible penalties? The minimum could be minimum of 5 days of jail, but no more than 6, or 5 days of jail is the minimum. 6 months of jail is the maximum possible penalty. Do you understand that?
Yes.
Or a fine not less than $250, but no more than $1,000. Do you understand that?
Yes.
Do you understand that the court is not bound to follow the recommendation that's been provided through argument or recommendation from the parties? Do you understand I'm free to sentence you to what I believe is appropriate, and that could be up to the maximum possible penalty?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney? And in particular, I'm going to say that probable cause section where it basically says what happened and why you were charged with the crimes.
Yeah.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty today because you are in fact guilty of that offense?
Yes.
Mr. Felisky, may the court use the probable cause section of the criminal complaint to find a factual basis with the statement made by Mr. Beechler?
So stipulated.
Has anybody made any threats or any promises to you for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
I am.
Do you have any questions for the court or for your attorney before I proceed?
No, I do not.
As to count 1 OWI second straight offense, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged in and dismissed. A judgment of conviction will be entered today. Is there, I forget if there's restitution, and there may be, that was settled with the insurance?
There's no restitution request. We checked with the victim. They did not want there to be a restitution request because in consultation with their attorney, they thought it might negatively affect how they get that somehow.
All right, I think I recall that's what you said at the last hearing. Okay, so Mr. Schmidt, argument and sentencing recommendation.
I'd ask the court to follow this recommendation. The defendant, his only prior history is his other OWI from 2021 in Mesa, Arizona. This is a case where the victim, his worst injuries were caused by being dragged under the defendant's car. According to the victim, he doesn't remember much. He just remembers that he had to be removed from underneath the car with assistance of first aid responders and had pretty horrific injuries. That's kind of detailed in the victim impact statement. The defendant, his account was something like, he doesn't know how the victim got under there. He just did somehow. There was a witness at the bar where the victim was struck by the side of the road. He said that there was a second vehicle that first struck the victim, and then the victim got thrown underneath the vehicle of Mr. Beechler. Mr. Beechler did stop his car and get aid immediately. He also, while he was in custody, everything law enforcement went to him for like getting consent and looking at like phones, vehicle, etc., to try to find evidence of the second vehicle or locate who it was. He was aiding in that. We never did find the second vehicle. It's hard to say how much of this is Mr. Beechler's fault and how much of this is the first vehicle's fault. Mr. Beechler did do a good thing in when he did collide with someone to call the police and get that person help. On the other hand, Mr. Beechler was intoxicated and he shouldn't have been behind a motor vehicle and somebody did get harmed. Is it possible that even with those circumstances that this victim wouldn't have been harmed if Mr. Beechler was intoxicated? There are just things we'll never know in this case. So for that reason, I think the aggravated guidelines are appropriate, and I'd ask the court to follow them. Thank you.
All right, thank you. Mr. Felisky?
Thank you, Your Honor. I will first note the applicable credit here. Mr. Beechler appears to have 32 days of credit. He was brought into custody on this offense on November 2nd, 2025, and was able to post cash and was released on December 3rd of that same year.
It was already set the time. Good time. Sorry, I didn't mean. to interrupt.
No, I'm just reflecting on what I'd like to say, and I think I'll start out by saying that I grew up with alcoholism in my home. And I think that the thing people miss about alcohol in that regard is that it isn't just the physical harm, the mental unwellness, the behavioral changes that really impacts people. They do play a role. But when I was thinking about this case, the thing I was struck by was that when it comes to alcohol and alcoholism, for the individual that's suffering from that, it's a question of misery. It's someone who takes all the gifts that their parents give them, all the love and care their friends and family and community can provide them, and they drown it. They drown it in alcohol. They let misery win. And in my life, it kept winning and winning. And one day that person made a decision not to let it win anymore. And by that time, for some things, it was too late. But that was what made the difference. And sitting here today and speaking with Mr. Beechler and having spoken with him with this case as it's proceeded, I know that he has made the decision not to let misery win. He made that decision, as the state noted, perhaps from the get-go. He took accountability immediately. He got out of his car. He called law enforcement, knowing that they were going to be there, that he would likely be going into custody, that things would get very difficult for him. He made the decision to not let misery win when accepting responsibility here, when taking this offer from the state, when accepting up until, as the court noted, the aggravating factors, additional time in custody, taking accountability for having committed an OWI, taking accountability and responsibility for committing that sort of action by having his license revoked, by requiring an IID in his vehicle. He's taken accountability and responsibility here and has not let misery win by dwelling on this, by thinking on it and reflecting it. One of the most notable things I found about Mr. Beechler has been the degree of devastation and regret and contrition that he has shown stemming from this incident. It has truly devastated him. And in some ways, I think that's healthy. I think a terrible thing happened that night. And while Mr. Beechler perhaps was not the cause of all that happened, he is here and is ready and is willing to admit his part in what happened. In the time since this has happened, he has continued to not let misery win by working on getting his HSAD in the jail. I believe he's waiting for some paperwork to finalize and finish that process. He's been working on getting custody back from his son, and following the proceedings here today, following the resolution of this case, he does plan to return back to Arizona to continue seeking that custody. I think looking at the galleon factors here, Your Honor, this agreement is appropriate. It protects the community. The community has been and will continue to be protected by these deterrents, by these requirements that Mr. Beechler will be required to follow through on. I think it's appropriate given the nature and gravity of what happened here. And I think looking at his character, perhaps most importantly, Your Honor, I believe this experience has truly changed him. It's regrettable that this is what it took, but it has changed him, and in some ways it's changed him for the better. He's been able to refocus on what truly matters, which is his family. He's kept himself busy and occupied through employment at 2 different jobs. He has been working on his hobbies, finding better ways to express himself and to work through stress without drinking alcohol and getting behind the wheel of a vehicle. And perhaps the other thing that has really struck me about Mr. Beechler is his focus on the victim. Every opportunity that it has come up, every time it has been mentioned in our conversations, he's expressed nothing but regret and shame for what happened. In fact, several of the first times that we met and spoke together, he started out by asking, is he okay? How is he doing? I think that says quite a lot about his character. I think that says a lot about how he has thought about this process and what happened overall. And I think that it is very indicative that this is not going to happen again. Overall, I think under the galleon factors here, I do think that this agreement is appropriate, and I would ask the court to follow it. Thank you.
Thank you. Mr. Beechler, is there anything you want to add or you want to say to the court?
Excuse me. I know that Jackson and his family aren't here, but I wanted to take accountability for the decisions that I made and tell them that I'm deeply sorry for the pain and trauma that I've caused them. And that I'm going to do everything that I can to make sure this mistake doesn't happen again. Thank you.
Right. That was a very profound and touching argument, Mr. Flisky.
Thank you, Your Honor.
Operating while intoxicated cases are very serious, and in this case, you can see why. Mr. Beechler, this was a case where you were over the legal limit, twice over the legal limit. You were operating a motor vehicle, not just operating, you were driving on a road or highway of the state and county, and you hit a human, and the human was seriously injured. On the other side, you were the second car to hit that human. Had the first car not hit Jackson, perhaps you would not have hit Jackson either. There's no way to tell. If we could go back in time and we can change some things, I know we would, but there's, as Mr. Schmidt stated, there's no way to determine the percentage of your fault in Jackson's injuries or the phantom car who was never caught, their fault.
And that's where this courtroom chapter comes to a close. But the bigger lesson extends far beyond this sentence. This case reminds us that accountability in court doesn't erase the consequences of a single decision. The judge recognized the defendant's remorse and cooperation, yet also made it clear that driving under the influence can change lives forever in just a few seconds. One unanswered question still lingers. If that mysterious first vehicle had been identified, would the outcome have been different? We'll never know. What we do know is that the victim, the defendant, and their families will carry the impact of that night for years to come. Justice isn't always about finding a perfect answer. Sometimes it's about accepting responsibility for the part you played. What do you think? Was this sentence fair? Or should the court have gone further?
and Jackson's injuries. But everybody does agree there was another vehicle. They just weren't able to determine who it was that was driving that vehicle or the vehicle itself. But you're standing up and you're taking responsibility and you're being accountable for your actions, which is a positive thing. Not easy to plead guilty to a crime. And it's definitely not easy to plead guilty to an operated while intoxicated offense. Because in the state of Wisconsin, once you get your 4th lifetime revocation of your driver's license. And that's a big deal. When you live up here, you live where we do in Wisconsin, you need a driver's license. It's very difficult to be dependent upon another person or other persons to be able to get you anywhere you need to go. It's, nobody says otherwise that this is a serious offense. Hopefully you're doing better and you understand